Soutphommasane, can you address just briefly any international law in relation to that, the free speech?
Sure. Well, why don't I start with the international law? The ICCPR, the International Covenant on Civil and Political Rights, makes clear that freedom of expression is a fundamental human right. But it also recognises that it's not an absolute human right, that it can be limited for certain reasons, provided that measures are proportionate. Hate speech in the area of race is clearly stated in that particular covenant as one area where speech can be limited. So Article 19, if you want to get technical about it, says that there's freedom of expression, and that's fundamental. Article 20 makes very clear that this does not extend to race-hate propaganda, as the language of the time put it. You have to read Article 19 and Article 20 together. Now, I know that there are some people who have very enthusiastically cited Article 19 of the International Covenant on Civil and Political Rights, but this has to be accompanied by a reminder that Article 20 exists too. As for my concluding thoughts, I believe there's been too much heat and not enough light in this debate, and the notion of freedom has been invoked in a manner that has been coloured by ideological polemic. We need to have a sober, mature debate about this. We should not be debasing the concept of freedom through ideology. If we are to value freedom, we should not be giving complete liberty to those who have social power. That great philosopher Isaiah Berlin once warned us that total liberty for the wolves means death to the lambs. We should heed that warning. And also, when we're on the topic of free speech, as Les mentioned, there are many restrictions we have on free speech. Our parliamentary standing orders, indeed, House Representatives, in the Senate, in each of the state and territory parliaments and assemblies, all have standing orders which require parliamentarians to refrain from offensive language. We have, in the majority of our states and territories, criminal summary offence legislation, which means you can be imprisoned or fined on the spot if you should be using offensive language in public. We have defamation laws, which mean that you can pay six-figure damages for calling people names or using offensive language. One radio broadcast not long ago was penalised $280,000. Why? Because he called a lady a grub. He called her a silly woman. A restaurant review in which the reviewer said that some dishes were simply unpalatable and that the restaurant in question was a questionable addition to the culinary landscape. That ended up with Fairfax Media paying damages of $160,000 to three individual plaintiffs, $480,000 for an unfavourable restaurant review. So I'll leave you with this question. If, as a society, we can ask our politicians to refrain from offensive language, if we accept that police can summarily arrest you and imprison you for offensive language in a public place, if we accept that you can pay $480,000 worth of damages for saying some dishes were unpalatable, why is it not acceptable then for us to hold people accountable for acts that offend, insult, humiliate, or intimidate someone? Not because of what they say or their ideas, but because of who they are and their race, things they cannot change. I would like to ask why exactly it is that so much attention is being placed on this particular section of the Racial Discrimination Act.